Welcome to The Explainer. Have you ever stopped to think about how a simple idea can become its own legal person? I mean, something that can own property, sign contracts, and even get sued? Well, today, we're diving into the legal magic that gives a company a life all its own. It's a massive part of our economy, right? But it's also kind of weird. How does a business, which literally starts as just an idea in someone's head, transform into something the law recognizes as a completely separate person? You know, this classic quote from Justice Marshall just nails it. A company isn't something you can physically touch or see. It's an artificial being. It's a legal creation that only exists because the law, and all of us, agree that it does. And it's no surprise that legal experts have argued for ages about what this personhood really is. The fiction theory says it's just that, a useful legal story we all go along with. But the realist theory goes way further, seeing a company as a real, living organism with a will of its own. Others are more practical, seeing it as just a convenient symbol for its owners or maybe a special permission slip granted by the state. Okay, so let's say you're ready to create one of these legal persons. Your first huge decision right out of the gate is choosing its form. And trust me, this one choice changes everything about who can own it and how it's managed. So you've really got two main flavors, private and public. A private company is way simpler to start. You only need 2 members to get going. The key thing, though, is that its ownership is restricted. A public company, on the other hand, well, that's the big leagues. It can offer shares to anyone, but that comes with a lot more rules, like needing at least 7 members just to start. And for a brand new venture, that simplicity is golden. I mean, being able to form with just a couple of people, facing less public scrutiny, and keeping your finances private, that makes it the perfect launchpad for most startups. But the choice isn't just a simple private versus public. There's this whole other powerful category that shows up when the government itself is the one calling the shots. When you're talking about government ownership, there's really only one number that matters: 51%. That right there is the threshold, the line in the sand that defines a totally different type of company. So if a government holds at least 51% of the paid-up share capital, boom, it's a government company. That controlling stake is what defines its status. And get this label even extends to any companies that it owns. All right, let's switch gears a bit. We've talked about what a company is, but how is it officially born? Well, that process is called incorporation, and it's a series of very specific legal steps. The whole path to incorporation is actually pretty logical. It all starts with getting digital signatures and locking in a unique name. Then you have to draft those all-important foundational documents. Finally, you file everything, and if it's all good, the government issues the official certificate. And you should really think of this certificate as the company's official birth certificate. The moment it's issued, that's it. It's conclusive, undeniable proof that the company legally exists and is ready to operate as its own separate person. So, our new legal person is officially born. Now what? Well, it needs a purpose, some limits. It needs its core DNA mapped out. And that DNA is all written down in the Memorandum of Association, or MOA for short. This is basically the company's constitution. It sets the absolute boundaries of what the company is legally allowed to do. Seriously, it's the single most important document defining its entire existence. The MOA is built on 6 critical sections or clauses. It spells out the company's name, its home base, how much liability the members have, and the max amount of money it can raise. But the most important one is the Objects Clause. This one defines the exact purpose of the business, what it was created to do. So, what happens if a company goes rogue and does something outside of what's listed in its Objects Clause? Well, the law has a fancy term for that: ultra vires, which is just Latin for beyond the powers. If a company set up to sell software tries to buy a fleet of fishing boats, that contract is completely void. Legally, it's like it never even happened. So, if the MOA is the big, grand constitution that sets the company's external boundaries, there's another key document. This one is all about the internal, day-to-day life of the company. It's called the Articles of Association. Now, the hierarchy between these two is crystal clear. The MOA is the supreme ruler. The Articles of Association, or AOA, lays out all the internal management rules, but it's always subordinate. The AOA can detail how a company will achieve its goals, but it can never, ever contradict or expand what those goals are. Because these documents are public, the law has this pretty tough rule called the doctrine of constructive notice. What it means is that anyone dealing with the company is legally assumed to have read and understood its rulebook. You can't sign a contract that violates the company's charter and then just say, oops, I didn't know. That excuse won't fly. But this raises a really good question. What happens when the problem isn't your fault as the outsider, but it's an internal screw-up by the company? What if they didn't follow their own procedures to approve a contract? How are you supposed to know about that? Thankfully, the law has an answer. It's an important exception called the doctrine of indoor management. This rule protects outsiders. It says that while you have to know the company's public rules, you're totally entitled to assume that all of its internal, indoor procedures have been followed correctly. But this protection isn't a get-out-of-jail-free card. It has its limits. It won't protect you if you actually knew something was wrong, or if the situation was so suspicious that any reasonable person would have asked some questions. And it can never, ever be used to make a forgery valid. So there you have it. We've traced the entire journey from an abstract legal concept to a fully formed entity with its own DNA and rulebook. We've broken down the process that gives a simple idea a legal life of its own. Now that you understand the blueprint, the only question left is, what kind of company would you build?